Good morning. Today is January 13th, 2025. Welcome to another episode of Legal Grounds Morning Cup. I'm your host, Texas consumer and real estate attorney, Benjamin Sanchez. Today, I will briefly discuss the first exchange of information and documents that are due after an answer is filed in a Texas lawsuit, otherwise known as initial disclosures. In Texas, as in most states, we have rules of civil procedure when you file a lawsuit. And within those rules, you are allowed to conduct what's called discovery, where you ask the other side for information and documents and writing, among other things, and then they have to respond. So in the discovery process in Texas, when someone files an answer, you can be the one suing, you can be the one filing the answer, but when the initial answer is filed, then that starts the discovery period in Texas. And the discovery period is that period of time where the parties get to ask each other questions in writing and respond and do depositions and all sorts of other things. And so it used to be in Texas that you could start right away. However, the rules changed a couple of years ago to now when the answer is filed, the discovery period has been pushed back for 30 days because there are now initial disclosures, which I want to get into here and show you. So under the Texas Rules of Civil Procedure, we have initial disclosures here that are Rule 194, and more specifically, 194.2. And when you look at the disclosures, you'll see here 194.2, and that they are due within 30 days after an answer is filed. Well, what information and documents must be produced within 30 days without a request? If we go through here, you'll see that there are about, 12, 12 items. And the first one is, are the parties' names correct? So maybe someone sued you and your name is incorrect, or maybe you think that the plaintiff's name is incorrect. And so the court wants to know, and the court requires through the rules, everyone exchange their correct legal names. The second is, are there any other potential parties that belong in this lawsuit that could potentially be named and brought into the lawsuit? You may not have to bring them in right away, but is there somebody you think that could be a potential party? If so, you need to put that information down. The third thing is basically your legal theories and general and facts. And so you don't have to produce all your evidence. You don't have to produce every single fact in detail. But as you can see, it says the legal theories and in general, the factual basis of your claims or defenses. Most of the time, on the plaintiff side at least, those facts and theories will be almost duplicated from the petition. However, in the defense side, you may have defenses or affirmative defenses that are pled, but that don't have a factual basis in the answer. And so you must put those factual basis. You can't just say, see my answer, because the answer more likely doesn't have a factual basis. And then this is number four, you have your economic damages. This is not all your damages. This is just sort of more like out-of-pocket economic money damages. Obviously, there's pain. There could be pain and suffering in a lawsuit, mental anguish, those sorts of things are hard to quantify. And this question is not asking for what you consider those to be. It's asking you for what your economic damages are, and your economic damages are defined under the law. But generally speaking, it's your hard cost money damages. It could be estimates, right? Maybe you haven't spent the money, but this would be the money that you'd have to spend to repair whatever the issue is that's the subject of the lawsuit. Number five, we have to have, all the people that you think have knowledge, of facts that may be relevant to this case. Okay, we need to identify who they are and give the contact information so that the attorneys and parties can contact these people and see what they know. Number six, this is where we get into a little bit of a hiccup with, especially with attorneys in Texas, is because six actually asks for documents that you may use to support your claim or defenses. However, if you look at that line item, it also says that instead of doing the document production, you can just do a description by category and location of all the documents. And so attorneys sometimes play games. Generally, here at Sanchez Law Firm, we provide the documents as part of the initial disclosures. But I've had more and more attorneys play games here and just say, "Oh, well, our documents are at our office, and you can come, figure out a date and time to come look at them." When it would just be easier for them just to give us the documents. But technically, the rules allow for that. The other thing is they could be located, at someone's home or a business, and technically you can say, well, these are the documents that we have, and this is where they're located at our client's business, or if you're representing an individual, our client's home. And then, you have to ask to visit the business or the home to look at that. Number seven has to do with any kind of indemnity and insuring agreement. So if you have insurance, you have any kind of indemnity agreement, that would need to be disclosed. Are there any prior settlement agreements? You need to disclose that, because in Texas you can get a credit off of someone else's settlement of that part of the claim. Remember, in Texas you can't double recover on your claim. So if you have $100,000 damages and one of two parties settles for $25,000, then you as the remaining party get credit for that $25,000, and now the amount that the other side can go after is only $75,000. So that's important. Any witness statements? Witness statements, sometimes people think of witness statements as formal, but under the rules, if you read the rules, they could be informal as long as they're in writing and attested to or signed by the person who made the statement. It gets a little bit tricky because, we can play games about whether emails or letters are considered statements. I think most attorneys just assume that those are not statements and that they're really looking at either kind of a formal statement or an affidavit or a declaration. So, that sometimes gets into a little bit of dispute. If you have a personal injury lawsuit, the next two are relevant for that. You can either disclose the medical bills, right? Or you can get a document that allows you to get the medical bills. And then if you do get the medical bills, in number 11, you have to produce the medical bills that you received because of the other side's, consent to get the medical bills. And then lastly, you have a responsible third party. That just means separate from a potential party. You may have someone who's outside the lawsuit that you believe may be responsible for the plaintiffs. Usually this is done by the defendant, because the plaintiff will just name all the parties they think are responsible as a defendant in the lawsuit. But sometimes the defendant will say, well, we don't think that we're responsible. We think this other person is responsible. And when we try this case, we want that other person to be able to be considered any kind of liability. Now, just to be clear, the initial disclosures are due 30 days after the answer. And the rules here, let's see here. We've got, let me just look at it here. So if you look at here, Rule 194.2A, it says a party must make the initial disclosures within 30 days after the filing of the first answer or general appearance, unless a different time is set by the party's agreement or court order. Okay. Generally speaking, however, you cannot start discovery in Texas until the initial disclosures are served. So the discovery period under another rule says that the discovery period starts when the initial disclosures are due. Now, some attorneys have tried to play games with that language, because what they'll do is they'll say, well, it's when it's due, not when I actually give you the initial disclosures. And then they want to start discovery by sending discovery requests, even though they haven't complied with the rule for initial disclosures. And I've been successful in arguing to the court, and I think it's the intended consequence of the rules that you cannot start discovery unless you serve your initial disclosures. So if the initial disclosures are due 30 days after the answer, but you do not serve your initial disclosures until 90 days after the answer, that means you can't start discovery until the 90th day, right? So the discovery period starts when they're due, and due, I think, really means when they're served, because in this rule, they're required. The initial disclosures are required, and therefore they're due, and that's the way we see it. Now, this morning, I had a hearing on just this issue, which is why it's so fresh, and why I'm bringing it up. And thankfully, the trial judge, agreed with our argument that the disclosures had to be done first before you can ask for discovery. I hope this has been helpful. If you file your own lawsuit, or you're not represented by counsel when you defend a lawsuit, or you're helping your attorney, please note that when your attorney asks for information and documents right away, it's because these initial disclosures are due. Sometimes attorneys will certainly ask for that information even before they file the answer. But if an answer needs to get on file because of a deadline, the whole point is to work with your counsel or yourself if you're unrepresented, and make sure that that information and documents are served within 30 days after the answer. Hopefully this has been helpful. Thank you for joining us for another episode of Legal Grounds Morning Cup. Have a wonderful day. Bye-bye.